Welcome to Pretty Lies and Alibis. Let's seek the truth and travel the long road to justice together. What you know, Alibis? Welcome to another episode of Pretty Lies and Alibis. I'm Gigi. Good to have you here. It's Friday. We made it to the weekend. Hope you guys have something fun and relaxing planned. I know it's a long weekend for a lot of you. I'm looking forward to some time off. I'm going to hit the lake one day and just chill out. You guys know the drill. Subscribe, like the video, share it with your friends. And if you want notifications, hit that little bell icon. Music fact of the day. What was the biggest song that came out of the 1960s? That's Chubby Checker's The Twist. It was the only song to ever hit #1 in 2 separate runs. All right, let's jump in. There will be another hearing on September 6th, so the judge can rule on Sergeant Corbett as far as what he intends to present at trial. A lot of this is slides relevant to Donna Adelson, including Celebrite extraction, iCloud data, email accounts, other records provided in discovery. So we'll see what he rules on that. Before we start, the judge reminds Donna that she is waiving any conflicts having Dan Rashbaum represent her. As you know, he represented Charlie at his trial last year. We get into the motion to dismiss the indictment due to pre-indictment delay. And the defense gets up and says 2 components need to be shown for this to be dismissed. The first is delay and then prejudice. He goes through a brief history. The murder was in 2014. Donna was a suspect back in 2016. The affidavit that was released showed that. And the defense points out that the presentation that the state intends to introduce is pretty much the same as it was in 2016 back at Katie and Sigfredo's trial. Says Donna could have been charged back in 2016. They had affidavits for certain individuals back then, and she could have been charged at any time after that. Now, Rashbaum admits there's no statute of limitations on murder, and the judge agrees. He said much of the evidence at the other trials is the exact same as what we will hear. The only new evidence, which we don't think is evidence, is her going to Vietnam. They're using texts, emails, and wires as the main part of their case. It's 9 years past the murder, but if you look at it under 11th Circuit law, it was certainly a time delay. You have to look at the prejudice component. There's records that no longer exist that Donna needed to defend herself against their case that will be brought in by Sergeant Corbett. Again, the subject of that hearing that's going to take place September 6th, as far as the slideshow he wants to bring in. The first is call patterns and call records beginning in May of 2014 through July of 2014, the month of the murder. He says because she wasn't charged in a timely fashion, there is no call pattern. It would have existed then, but not now. The phone record, it only kept records for 3.5 to 4 years. That would have expired in 2019, give or take. So she can't fully defend that point, and that is prejudice. He brings up the text where Donna says she's outside of Charlie's house. He said, we have to defend that because that's one of their main pieces of evidence. The way to defend that would be SunPass records, which are kept for 3.5 years, and that is a predicament for the defense. Before 2016, a month after the murder, the state pulled financial records for Donna. They pulled call and SunPass records for other co-conspirators, but not Donna. The second is a bad faith component. And under bad faith, you do not need to show a sinister motive on the part of the prosecution. Their strategy was to wait and hope that people would flip through offers of immunity and otherwise, and they waited, and now those records don't exist. We argue the alternative in this motion. If there's no dismissal, keep out these pieces of evidence. Not all the call records, but they can't establish a pattern because they don't have earlier records to show what pattern exists or if there is no pattern. If they would have gotten the SunPass information, it would have shown if Donna was at Charlie's house or not the night of the murder. Remember, Katie McBanawa testified at Charlie's trial just last year that Donna brought money to Charlie's place to give her It was wet, kind of moldy or mildewy. That's what we're talking about here. The defense says you would see Donna entered the turnpike. The judge asked if there's ways to travel to avoid that toll. The defense says the state's own witness showed that Donna entered the turnpike through their cell phone data. It wouldn't show her getting off the turnpike, but it would show her getting back on the turnpike. They would know where and when she got back on, and it would have shown if she were there at Charlie's or not, and we wouldn't have to guess. He said it's the number one piece of evidence in this case, her being outside his house, other than the wiretaps. That's what ties her to the murder afterwards. The judge looks at some U.S. Supreme Court cases, and the judge points out that the prosecution has an affirmative duty not to charge anybody until they have probable cause and not to clog the courts with cases they can't prove at that moment. The defense says they have to be held accountable to what has changed. And when you look at the exhibit list and compare it to the one in 2019 from the previous trials, it's essentially the same exhibit list, and we're not even talking about Charlie's trial. It contains things they had back then: emails, wiretaps, checks that essentially ties their case together against Donna. What hasn't changed? The Dolce Vita recording, and Donna wasn't there, so it doesn't apply. They had it back then, just not a clear version. The defense says 95% or more of this case is the same witnesses, same evidence. The state gets up to argue their side and say that there's two pieces of evidence: the phone records, they're all call patterns that occur at major times during the planning of the murder. She points out Katie and Sigfredo have children together. They're a couple. They talk every day. That is expected. Every trial, the defense picks a random day that summer and shows there's calls on days where nothing big happened, nothing substantial. They say that law enforcement tried to get records before and after the shooting. The judge asked if there's an issue why these records wouldn't be pursued. The state says because these call records are revolving around the attempted murder and then the actual murder, which are the most relevant times in this case. As far as phone records, the state did not purposely not indict her until after these phone records couldn't be gotten. There's no bad faith. The judge asked, was SunPass followed up on after probable cause was established? She said they tried to get them late last year. They don't know if it was exculpatory or not. But Donna texted Charlie outside your house, and Katie Magbanawah testified that Donna was there at Charlie's before she got there. The state says, we think the SunPass records would have been inculpatory. The state did not zero in on Donna going to Charlie's until 2023 because in her proffer last year, Katie said Donna had been there. The judge asked for clarification. Is this new information through a proffer? And the state says yes. They learned that through Katie's proffer and information she gave them leading up to Charlie's trial. Donna's phone locations and messages have always been in the records, and they didn't zero in on that she is the source of the money drop until Katie testified to that just last year at Charlie's trial. Donna and Harvey came to Charlie's house before her and mentioned that the money was wet, and she thought Donna may have washed that money. They go on to say, we found evidence in phone records she did go there through locations and the message saying that she was outside his house. The defense gets up and says he was retained by Donna in 2016, and every trial has been on YouTube. And if they believe the SunPass records were so needed, they could have been requested before they were unable to be received. The defense says at Charlie's trial, he tried to get them and couldn't. The state says if the court denies the motion, they would ask the defense not be able to argue in trial. She wasn't indicted until 2023 because investigators didn't believe they had enough evidence to indict her. The judge asked if they didn't know what they had in the text messages until Katie's proffer. And the state says her testimony made them zero in on the fact that Donna could have dropped money off to Charlie. We know she was going to Tallahassee after the murder, but Katie began cooperating leading up to Charlie's trial, which revealed this information. The defense responded that he was retained in late summer 2016 to represent Donna. Those trials started in 2019 with Katie and Sigfredo, and they did try to get the SunPass records. He said, but we couldn't because back in 2019, when this went to trial, Rashbaum and Donna were not active parties. They did try when Charlie was indicted, but it didn't exist at that point. The defense says they wanted dates from cell phone activity from 2012 to 2014, but at that point, they weren't available. They got records for a 4-month period of time. And the defense, they got financials years in advance, but why not cell phone records? They're putting in emails from 2012, so why not go back that far with the phone? He says their sample size is too small and that shouldn't come in as evidence. As far as Katie's proffer, the defense says they had that message well before she gave her proffer. He said, I saw it in discovery before her proffer. The judge says, looking at it in bad faith, is it possible to not know what this one piece of paper meant until later? The defense says it's unlikely, but not impossible. How did they not think 10 minutes away outside your house was important? The judge reminds the defense that the state didn't have the benefit of Katie's proffer. The defense says that, according to what he can remember, Katie did not mention them being outside the house in the proffer, but she said it on the stand. And he says it's also a fairness argument. The judge decided to reserve ruling on that. He needs to look at a transcript of Katie's testimony about Donna being outside Charlie's and what was said. The next motion they took up was to hold the trial in courtroom 3B. The defense points out there were interactions at Charlie's trial between the jury and the gallery, and he tells the judge, "You're great at courtroom control." The judge interrupts and laughs and says, "But you still want a different courtroom. Don't butter me up. Get to the point." Everybody kind of laughs. But the judge says that in researching, he didn't come up with anything about a right for the case to be tried in a different courtroom. The state says they got an email from the Markell family wanting to keep this trial in that bigger courtroom. And from their perspective, it's practical. There's a bigger screen. There's multiple screens for the jury to look at all of the demonstrative aids that are going to be put in this trial. And there's also one for the witness. In 3B, that smaller courtroom, there's only one monitor for all the jurors to look at. Also, the clarity of the photos is not as good, and there is an issue with the sensitivity of the USB cord that is attached to their computer. The judge says that he won't hesitate to break out the handcuffs if needed for the public attending, and everybody laughs, and he denies that motion, so the trial will happen in that bigger courtroom. The next issue was the motion to suppress wiretap interceptions. That same motion was filed in Charlie's trial and denied. Rashbaum said he wasn't going to argue anything else, just to rely on his filing, which actually I did an episode on, I believe, yesterday. The state says they've met the standard by showing other investigation methods were too dangerous and that wiretapping was the best way to investigate the murder for hire plot. It was to reveal the conspirator's identity and the roles and the hierarchy of the conspiracy. The circumstances of this case was getting a lot of records, including the ones the checks written to Katie came from. Those weren't received until 2016. On those wiretaps, there was chatter between them on how to handle the blackmailer, and that was brand new communication. That could only have been received through the wiretaps, and new evidence was created with those wiretaps. The judge will issue a ruling at a later time. On the motion to use a jury questionnaire, he denied that motion. There will be an examination on pretrial publicity and hardships to be able to serve on a trial this length, and both parties can follow up with questions of their own during jury selection. The motion for pre-arrest silence, state didn't oppose it. It was granted. For wealth evidence, the defense says the state intends to call Mary Hull as a summary witness to talk about wealth records. They put in records showing combined wealth of all the Adelsons, and this is clear under case law. Evidence of a defendant's wealth can come in when relevant in the case, but using it to show class bias can deny Donna a fair trial. Their wealth has no bearing on this case regarding if Donna participated in premeditated murder. The defense says they do stipulate that checks were paid out of the Adelson Institute to Katie, and $100,000 was paid to Katie on July 18th, 2014. And they're not disputing that the Adelsons had that ability to pay that amount. There's evidence of a car that was given to Katie that belonged to Donna's husband, Harvey, and they stipulate that. But why show millions of dollars in wealth, and where's the relevance? The state says this is a murder for hire, and the state is allowed to prove that Donna had the money for payments, for gifts, for cars that was received by the killers, and it's relevant to show they had the ability to pay the alleged $1 million bribe before the murder. This is important to the jury to know the motive and the means that this was executed. The judge grants in part and denies in part evidence that demonstrates Donna or a co-conspirator to pay Katie or any other co-conspirators. The state will be allowed to show that. A presentation to all assets will not come in. Mary Hull being examined if Donna had assets to participate in the $1 million bribe will be let in. The defense says they won't dispute the $1 million offer, and they're going to be the ones to bring that out themselves. Moving on to Jeff Lacass's testimony, the defense says you ruled in our favor in Charlie's trial about the hearsay testimony, but what happened is the state asked the question about this piece of evidence to Wendy. She denied she said that, and the state backdoored that in to impeach her. The judge says, I wouldn't say backdoor. It may not come in for one reason, but it doesn't exclude its use in other ways. The defense says this is different because the question to Wendy in that trial was about a statement Charlie made. It was the statement of a party opponent. In this case, if they ask Wendy, it doesn't fit. It's hearsay. The state disagrees. They say it's in furtherance of a conspiracy if Charlie is saying he's looked into hiring a hitman and how much it would cost back in the summer of 2013. Katie couldn't remember if he said $15,000 or $50,000, but how can that not be in furtherance of a conspiracy? If she denies it, they would call another witness for impeachment. The judge is going to do some further research and reserved ruling on that issue. Moving on to Wendy Adelson's testimony. The defense says the state's opinion may have possibly changed. How does Wendy's book about human trafficking have anything to do with Donna's trial? As far as the name changes, they never testified that it had anything to do with Donna. And Wendy's denial of Dan's parents to see the grandkids has nothing to do with Donna. Asking about the Florida's grandparent visitation rights law, the state has agreed to not ask. And then he said they go back and forth. So I'm not sure where they stand on this. But ultimately, these questions have little to no probative value and they're prejudicial. Prosecutor Kappelman says as far as the book, she flip-flopped on it. It came up last time because Wendy denied wanting to relocate. She denied being disappointed. And that's the state's main theory of the crime was to relocate Wendy and the boys. That opened the door of her book coming in about her being married to a man where she's miserable, and it parallels Wendy's life. The state says as to the name change and denying the grandparents' visitation, it goes to the state's theory that she would be able to move to South Florida and erase Dan from the children's lives, literally and figuratively. The judge asked, is it not Wendy's right to change their names? And the state said it is, but the decision to do so goes to our theory. And a reasonable juror could possibly see this. The defense says Wendy is not on trial. This may be different if this was her trial, but it's Donna's, and it doesn't fit the relevancy standard. They're going to try to show what the divorce situation looked like and how Donna wanted relocation. And then you add this to the fire. When you do a balancing test, I don't think it's relevant. So he is going to reserve ruling on that. As far as Jailhouse recordings, The defense says they're not suggesting that Donna's statements don't come in, but they don't feel Charlie's should come in because it's hearsay and it's not in furtherance of a conspiracy. These calls were after Charlie was convicted. Some of the statements are inflammatory. And the judge asked if any of the issues are from consciousness of guilt. Donna's attorney says Charlie is talking about his trial and why he thinks he was convicted. Donna is responding, that's allowed in. And she may respond in part about travel, but Charlie's statements are not admissible. The state says these are statements made by Donna or adopted by her on a recorded line. We can't extract one voice out. She specifically talks about wanting to admit in the hot mic call, where there's talk of fleeing, talk of relocating, talk of self-harm. The judge is reserving that ruling. He needs to go back and review those calls. But he does say only the relevant ones will be allowed in, and if they are admitted, there will be limited instructions read to the jury. Autopsy photos, the defense is saying that it's admissible if not so shocking to defeat the relevance. There is no dispute with us on his death or how he was killed. In Charlie's trial, there were 10 exhibits. There were 8 photos, including x-rays, and he says it's clear what the state is trying to do. They asked those photos be limited. The judge says he isn't sure if any of those were used during the examination of Rivera, but doesn't it coincide with how the murder was carried out? The defense says, I don't know if they were used with Rivera, but they were used with the medical examiner. But the judge asked if the version of events that Rivera testifies to, isn't it relevant to the autopsy photos? The judge denies that defense motion, and those autopsy photos will come in. The next motion is to preclude travel as a consciousness of guilt. The state went to tremendous means to wait to arrest her until she was getting on a plane, and they say that's consciousness of a guilty mind. Can I imagine an innocent person doing that? And if so, it probably doesn't go to a consciousness of guilt. You can add that to the facts in the case that show she wasn't fleeing. She applied for a visa with the State Department, spoke openly with friends about it, spoke to her attorneys about it to be sure she wasn't committing a crime, and used her own passport, booked a hotel, and left from her home airport. When you look at the totality, you see this is occurring. She traveled and always came back. The phone calls, she talks about it, why, and what she's doing. The judge asked if there's any other evidence that puts context on this travel. Were there internet searches about extradition, not just the purchase of the flight? The defense says, I think there's evidence that would show there were searches for places with no extraditions, but that's part of the totality and explanations that show they're not looking to become fugitives. They're talking about payments to a Vietnam villa. It was an investment with Charlie and someone in Singapore, but this property was sand. The structure wasn't even built. Donna and Harvey kept paying because that was the agreement with Charlie, and if they didn't pay, they would have lost whatever they paid into prior. The state says there's evidence this flight was demonstrating a consciousness of guilt. She got an emergency visa. She booked a one-way flight to a non-extradition country, and the defense can address it on cross-exam and let the jury decide. How is it a 403 problem if she's just going on vacation? The problem for them is there's plenty of evidence it was Donna fleeing. The judge rules this comes in. The jury can decide if Donna was just researching a vacation or seeking to avoid prosecution or a consciousness of guilt. They move on to the state's motion in limine that Rivera's gang affiliation shouldn't come in. The judge says in the last trial it was denied in part and granted in part. The defense says they have to bring up the Latin Kings because his affiliation is how and why Donna reacted. The state brought that up in the bump, saying that he's in the gang and Rivera wants to get paid. Part of the reason she acts the way she does and talks the way she does is because Rivera is a member of the Latin Kings. The state says the name Latin Kings is not in any of the evidence they plan to introduce, but they could use the term criminal street gang if they'd rather. The defense says the Latin Kings has more credibility in Miami just by name, And when she hears this, it affects how she does certain things. They think it's relevant and necessary for her defense for the term Latin Kings to come in. But the defense says he should be able to confirm with Rivera that he was the head of the Latin Kings in Miami. State says that's prejudicial. So they'll just see how things develop during the course of the trial. The judge says, as far as Donna conforming her behavior because he's a gang member, he does grant that coming in, but he will reserve ruling on naming the Latin Kings specifically. Another motion by the state was Rivera's mental health. There's no evidence his mental health affected his participation or testimony, and there's no evidence that he is currently experiencing any mental health issues. The defense does not plan to bring this up at trial, but if it comes up, they'll approach to decide that is granted, that his mental health will not come in. The next part is about demonstrative aids. The state plans to bring in videos, clarified audio on the Dolce Vita recording and the Matsuri recordings, wiretap call slides with rolling transcripts and a photo of who's speaking. The defense doesn't object to transcripts to the wires coming in, but they do object to the transcripts from the Dolce Vita and the Matsuri recordings coming in. The defense says you can't hear some of it. They're guessing on what was being said, and every other word you can't understand. He doesn't believe that that transcript should come in. The judge allows the transcript for Dolce Vita and the wiretaps to come in, but that Matsuri will not. The state can bring in the FBI agent who was there at the restaurant to authenticate that transcript. And the state wants to keep statements to elicit sympathy for Donna out. The state points out the allegations of how Donna said she was being treated in jail. She doesn't want it coming in. It's more prejudicial than probative. The defense doesn't plan to bring it in unless other things come in, but he will notify the court first if they decide to bring it in, and then they'll decide from there. The judge grants that motion subject to proper relevant evidence coming in. And that was it. So just a kind of fair on both sides, I believe. I love this judge. He is one of my absolute favorites. He's very fair to both sides, and he has a great sense of humor, and he's very laid back. So we're inching close to trial. Donna today looking well in jail. I have to say, I mean, she looks better to me than she did before. I think you can only know for so long to look over your shoulder because starting in 2016, we had all these arrests. Then we have Charlie. She had to know it was coming. So I don't think you can really get comfortable and just be at peace because you're always waiting on that moment. I've seen interviews with people who were on the run that said after a while, you kind of hope for it in a way because the stress of anticipating it takes such a huge toll. We will live stream that September 6th hearing. And as soon as opening statement starts, I'll be live streaming this trial every day. Come hang out with us. I'll keep an eye on the filings to see when he rules on this, and I'll do an update episode for you. But that's going to be it for this week. But we will see you either Monday or Tuesday. Have a good one.